Hello, I'm Ben Stepney. I'm a partner in the employment team at Thomson Stanley Passmore. And today I'm joined by Nick Hobden, who's partner and head of the employment team at Thomson Stanley Passmore. Now, a few months ago, we recorded a video about settlement agreements from the perspective of an employee who had just been offered a settlement agreement by their employer. So for today's video, we're going to flip that on its head and talk about settlement agreements from the perspective of an employer, talking about the pros and cons of offering settlement agreements, what they are and what employees need to think about before putting an offer to an employee. Nick, what is a settlement agreement and how are they used in an employment context?
Well, Ben, the answer is in the name. A settlement agreement is an agreement that settles a claim or several claims that an employee could bring against their employer. And it enables the employer to procure a waiver by the employee of all of their employment rights arising out of their employment in return for usually money consideration on a full and final settlement basis.
Okay, Nick. So when and why might an employer consider offering a settlement agreement to an employee?
Well, employers will tend to use a settlement agreement in circumstances where they have a problem with an employee that they need to resolve, usually by the termination of their employment. So it could be for someone who's on long-term sick leave, someone who's raised a grievance, where they're really only interested in getting some compensation. Circumstances where perhaps some sort of enhanced redundancy is offered on a one-off basis to employees. And what the employer wants to do is to give that money, pay that money over on an ex gratia without legal obligation basis, in return for which they want the employee to settle their claims and waive any claims that might arise out of their employment. So typically those are the situations when they're used most.
Thank you. So what are the advantages for an employer then of entering into a settlement agreement with an employee?
Finality, being able to have the assurance that when they've paid over the money to the employee and the employee's employment has been terminated, that they don't want any comeback. They want to avoid any claims being made by that employee. They want to wrap things up so that both sides go away, parting on good terms usually, and that there's no comeback, there's no potential future disputes or litigation that might arise.
Sounds ideal from an employer's perspective, but there must be a catch. What are the disadvantages from an employer's point of view?
Well, sometimes employers will get a reputation that they use settlement agreements too easily. So, for example, if their answer to most grievances or issues to do with disciplinary cases are to offer some money to an employee, then they may get a reputation for just putting their hands in their pocket all too often. And that can create a problem for some employers who will just be cast in the eyes of the employees as an organisation that will inevitably put their hands in their pockets and pay out some money. I think the other disadvantage is that they can be used to over-formalise or over-complicated a situation where the employee has decided to resign, but they're not intending to bring any sort of claim, or they are just simply suggesting that they both part company. So in that sense, they can escalate things into a more formal type of agreement.
I see. So taking that on board, if an employer decides that they are going to offer a settlement agreement, what are the key terms they need to be drawing up?
Well, they need to provide for how much money is going to be paid, firstly. They also need to provide for the amount of notice that an employee is entitled to and how that's going to be paid, whether it's whilst they're continuing to work down their notice period, or perhaps be placed on garden leave with certain restrictions, or maybe payment in lieu of notice. It'll also need to cover things like an employer's reference, any confidential information that needs to be kept confidential by the employee and not disclosed. The fact that there's been an agreement and there's been a money payment also needs to be kept confidential, and that's usually provided, invariably provided, in the settlement agreement. There will be provisions regarding employer references, and also typically there's a non-derogatory comment provision in the agreement on both sides, so that both sides don't badmouth each other once the employment has ended. So they can cover all sorts of softer issues to do with employment termination, as well as the harder ones of money and exit.
Okay. So once an employer's considered those hard and soft issues and to put together a proposal and puts it to the employee, would the employee always agree to terms?
Not necessarily. The way that this is normally done is that there's a provision in the Employment Rights Act 1996 which allows an employer to have what we employment lawyers call protected conversations. And they are a means by which an employer can make an offer of settlement to an employee and not have that turned around and used against them in any dispute that develops into an employment tribunal. So that's quite a useful opportunity for employers to share their thinking around why they want to enter into a settlement agreement, why they want to put some money on the table for the employee to accept. There's often a situation where that employee doesn't accept the offer and they'll want to go away and take some legal advice, or they'll want to negotiate, and that's a matter for the employer with the benefit of legal advice to think about how they're going to respond to that pushback from the employee. But generally speaking, these settlement sums tend to have a ballpark, so that essentially employer puts forward offer, employee says, well, that's interesting, actually I want a bit more for various reasons. And there can be some toing and froing, but generally speaking, in my experience, the employer usually finds that they're prepared to settle sometimes for a bit more than they were originally prepared to put on the table, but they are essentially investing in avoiding the risk of a further dispute and employment litigation, which could potentially cost them more. So sometimes employees reject the offer and say, no, I'm not going to go. It's a matter of principle, I'm going to stay put. And then the employer has to think about how they're going to deal with that situation, and again take legal advice as to whether, for example, in a capability situation, they're going to go down the capability route, or if it's a long-term absence due to ill health issue, whether they're going to go down the capability due to ill health route, or some other route such as a disciplinary case.
So Nick's explained to us what a settlement agreement is, what's in it for the employer, and what are the key terms to consider before putting an offer forwards. If your business is thinking about entering into a settlement agreement with an employee for any of the reasons that Nick suggested, then it's always a good idea to take legal advice up front before committing yourself to going down that route. And if you'd like to speak to a member of the employment team at Thomson Stanley Passmore, then please don't hesitate to get in contact.